Excellent. Thank you.
All right, let's go on the record. In 2026 P-125, an appeal was filed regarding the zoning administrator's determination of a screening agreement, which was a condition of the building permit. Mr. Hawk, are you ready to proceed?
I am, yes. Let me turn my video on real quick. Hi, would it be helpful just to give a brief introduction of myself, this project, and the grounds of our appeal?
Let me get a couple more administrative things done and then yes.
Great, thank you.
Ms. Hinkle, are you ready to proceed?
Yes.
So this is an appeal of an administrative decision made by the zoning administrator. I'm going to be using mostly the documents that were created for the building permit, not the actual special use permit, because obviously it references the statute, but my understanding is the agreement was a condition of the building permit. So that's what we're going to be talking about mostly. Also, in the room, can you introduce yourselves?
Amanda Baker.
Aaron Baker.
Elijah Baker.
And you are the property owners across from the solar farm, correct?
That's correct.
Okay. Now, Mr. Hawk, can you, now's time for you to do that.
Wonderful. Well, thanks so much for everyone. I'm sorry I couldn't make it down there in person. My wife and I just welcomed our newborn son, and I'm on baby duty tonight, so appreciate the flexibility of joining via Zoom.
Congratulations.
Thank you. Yeah, just a quick, so I work for, my employer is One Energy Development. I've been working on this, what we call Egalina Solar Project, going back to 2018 when we entered into a lease agreement with the Sollenberger family. We've been under contract with them since then. We received our special use permit originally in November 2022. After receiving that permit, we were able to secure an interconnection agreement with ComEd and a REC agreement to participate in the Illinois Shines Community Solar Project in 2023. After that, the 2024 was largely spent getting this project ready for construction. And to your note on the building permit, one of the conditions of that was meeting with the neighbors to discuss visual screens as they were defined in the ordinance. I defer to Alice on this, but my understanding is the ordinance that this project is held to is ordinance number 11-21-005 when the project got its special use permit in November. And based on that ordinance, one of our requirements was to meet with all the neighboring property owners, discuss the solar project, and come to a mutually agreeable visual screen. That ordinance defines the visual screen options as either an opaque fence or an evergreen tree screen or an approved combination thereof. In July 2025, we met with the neighbors of the project. There was 3 neighbors that qualified for a visual screen, including the folks who are there tonight. And we met actually in their front yard underneath a lovely shady oak tree to discuss the screening application. That was in July of 2025. And what we had proposed at that point was, when this project was originally permitted, we actually had 2 2-megawatt projects proposed that would cover 40 acres. The interconnection agreement would only allow for one of them. And so after working with our neighbors and the landowner, we agreed to shift the project to the southern half of the property, to put it 1,000 feet away from the roadway. Per our permit, our understanding, it would have been a cheaper solar project to build if it was up adjacent to the roadway. But we elected to move it south just to maximize our distance from our neighbors. We reviewed that in July 2025, when we met with all three of our neighbors, and what we proposed was a tree screening along the northern fence line of the property, or the project, that would provide screening for all three neighbors. And the options that the ordinance provided to them was either ask One Energy to install that tree screen or waive that tree screen and receive a payment equivalent to the installation and removal of the trees that we proposed along the fence line on the northern side of the project. Two of the neighbors agreed to waive that tree screen, mainly because, they farm the property and they weren't too excited about putting evergreens out in the middle of the field. Those roots would get down into the drain tile, and just cause issues for farming, et cetera. But we weren't able to come to an agreement with that payment amount that we received from a landscape architect that would equivalent to 1/3 of that tree screen. And so Aaron and I then talked about a variety of different options, including putting trees, on the property line with their home that we would install. We proposed 14 trees, which would have been 1/3 of what we proposed on the northern tree screen on the property line, and that's what I submitted as part of our appeal. We got that plan worked up from a landscape architect, and I provided that to Alice as an attachment for this appeal. So unfortunately, that wasn't able to meet the Baker's expectations either, and that's my understanding why we find ourselves here tonight. Happy to answer any questions or clarify any of those within that statement.
Is it your understanding that Ms. Henkel's opinion was made based on the new proposal that you provided as part of the appeal?
My understanding was that Ms. Henkel's opinion was based off the original tree screen on just the northern side of the project, and it did not address the visual impact in her statement of the eastern side of the project. And so that's why I went through the diligence of getting a second estimate provided and attached it to our appeal that showed 14 trees moving it up to the property line that we think sufficiently screens both the northern and eastern sides of the project for the Baker family.
So the second estimate from the landscape architect would move the screening from the boundary of the solar farm to the boundary of the Baker's property. Is that correct?
That's correct.
And do you know if the landscape architect did any looking at their property line to see how viable it would be to put trees there?
My understanding of the ordinance was we were required those plantings needed to occur on the parcel that's hosting the solar project. And so what the landscape architect proposed was planting 14 trees along the property boundary, but on the landowner's property who's hosting the solar project.
Okay.
And those would be planted in the area, just outside what's currently being cropped.
That's my understanding as well, so I was confused. I thought you said that it would be on the Baker's property. So it would still be on the parcel that hosts the solar farm, but adjacent basically to the road.
It would be in the northeast corner of the property line, in between the solar project and the Baker's residence. So it's along the property line, but on the host property. I don't know if that was, Alice, I don't know if I believe I included that site plan as an attachment to our appeal, but let me know if that's incorrect.
There is the site plan. I just don't, and maybe I've got a copy of a copy of a copy, but it does not, to my eye, show where you're proposing these trees. Is it along the access road that goes? So it's kind of adjacent to Reynolds Road and the property line that runs, what that would be, north and south?
In this visual layout, in the northeast corner of the parcel is where it abuts the baker's home. That little L shape of like kind of on the northeast corner, that's where we're proposing to plant the trees as close to the baker's residence as possible, but still on the hosting property, if that makes sense. And I have the plan that I originally shared with Alice. If I could screen share that, if that's beneficial, or just let me know.
But to your knowledge, that plan was not considered by Ms. Hinkle in making her determination, correct?
That is correct. That is my understanding.
You have anything else you want me to know?
No, I believe that's it. I just I think the landscape plan we attached that shows the 14 trees. That 14 trees, that was the number identified based on completing the visual screen, but also that was 1/3 of the original trees proposed on the northern boundary. So I just wanted to note that justification. But no, that's all I have. Thank you so much.
Okay. Ms. Hinkle. I guess I'll start with, well, do you have anything you want to start with? And then I'll ask you some questions.
I did have a few exhibits. And I'll go through those briefly. Zoning exhibit number 1 is a copy of tonight's agenda for tonight's hearing. Zoning exhibit number 2 is a copy of the petition for appeal that was submitted by Greenbacker and One Energy. Zoning exhibit number 3 is my determination dated May 14th. Zoning exhibit number 4 is a notice of hearing that was given to Mr. and Mr. Baker for tonight's hearing. And exhibit number 5 is a copy of the certified mail receipt and green card to Mr. and Mrs. Baker.
Without objection, those will be entered into evidence. So ordered. Do you have anything you'd like to say?
I have nothing further to add at this time. Sorry. One clarification. I did not have the landscape plan that is attached to the petition for appeal tonight when I was making my determination. So that was not considered.
Are you asking to consider that?
Yes.
I'm going to go off the record for a moment. So we have a couple of options here, and we will put this back on the record. I just don't. if Ms. Hinkle wants to reconsider, I think that's her right as the zoning administrator to have an option to reconsider. To do that, though, Mr. Hawk, you would also have to be in agreement to continue this hearing. We wouldn't cancel it. We would just continue it until Ms. Hinkle has an opportunity to consider that. And then if she stands by her prior administrative review or issues a new one, we would reconvene to consider that. If there's a change, to consider that change. Are you amenable to that? You're the petitioner, so you have a lot of say in this.
Yes, I'm amenable to that. I think that makes a logical path forward.
Okay, can we go back on the record? We had a brief conversation off the record to discuss perhaps going into recess in this hearing for a period of time for Ms. Hinkle to reevaluate based on the new plan proposed by petitioner. Petitioner has no objection to that. Ms. Hinkle indicated that she would like to do that. As to the Bakers, you're not, people hate lawyers, you're not actually a party to this, but obviously you have, probably the vested interest in what's going on here today. But I think from a procedure standpoint, this is the appropriate procedure to create a record moving forward, is to let Ms. Hinkle have that opportunity. What I don't want to do is me make a determination and then we go through this for another 6 or 8 months and a court come down and say, she should have had this opportunity, so you guys now get to do it all again. I'd rather take maybe a few weeks to do that rather than go to court, have to go through all those hoops and then come back. So other than you're not happy with that option, do you have any objection to giving her that opportunity to create a better record?
I don't want to say, am I just supposed to say object or not object? Or
You-
can I
you
say
t-
something?
Tell me what you want me to know.
Okay. What I want you to know is that this choice was never offered to us. The choice was either on our property or out in the field. And we don't have room on our property for these trees. We wanted them on the Sullenberger property, but it wasn't a choice.
Well, and it sounds like it's a choice now, though.
Okay.
So I think, again, we're better off doing all of our due diligence to make sure that if this resolves everything and everybody's okay, not happy, but okay, then they would maybe withdraw their appeal. I don't want to have a judge next February say, you guys get to do this all again. And you guys have to go to 8 court dates between now and then to get to the same point if we can do it in a few weeks. I appreciate your comment, but I'm taking from your comment that you're okay taking a look at this plan and having everybody consider it.
The one more thing is that they've already given us the money. So does that mean that we get to plant trees on the Sullenberger's property? If it would be the issue.
So I'm going to say that's not before me right now.
Okay.
That's a contract between you and the solar company. If you guys come to an agreement, then you guys have come to an agreement. And then they would withdraw their appeal if everybody's in agreement. And then I think, there's 50 ways to solve it. Having the courts do it is probably the worst. So if you guys can come to an agreement, that's the best. Giving Ms. Hinkle an opportunity to look at this new plan to see what it would do, I think is a good option. And if you guys, I'm going to speak for you, Alice, I know how much you like that. If you guys want Ms. Hinkle to maybe act as a go-between a little bit or be involved in this a little bit more, I think she would be a resource to say, let's make sure we're all on the same page and that we all have an opportunity to be absolutely clear on what's going on. So I think she'd be happy to do that. So with that then, this hearing is in recess. We will plan on restarting the hearing at our next date, which is August 26th at 5 p.m. There'll be no further notice. So this is your notice of that hearing date and time. And again, my hope is that everybody can get this worked out, but I'm happy to be here and issue an opinion if that's where we get. So we are adjourned.
Thank you.
Thanks all.
Thank you, Mr. Hawk. Good luck.
Thank you.